Hello and welcome to today's presentation, the first in the Know Your Rights series, 5 Legal Tips for People with Cancer. This presentation is intended to give general information and is not intended as legal advice. This webinar also does not establish an attorney-client relationship. There will be time for Q&A after the presentation, and I also want to say that I hope to be able to answer your questions at that time, but there may be instances I might have to tell you I don't know the information, either because it's not information I have offhand, or it might be too specific for today. However, I encourage you to fill out an intake with the CLRC so we can properly research the information. The CLRC stands for the Cancer Legal Resource Center. We are a program of the 501c3 nonprofit Disability Rights Legal Center. The CLRC provides information and resources to people affected by cancer, including patients, survivors, caregivers, and healthcare professionals. Our resources are free, regardless of income. The Know Your Rights webinar series was created with the generous support of CGen. As you can see, today is the first of the 5 webinars that are offered as part of the Know Your Rights webinar series. You can, at this time, register for all of the upcoming webinars. And even if you miss one, that's okay. They don't build on one another, so you can check them out and attend hopefully all of them or even just some of them. And we hope that you'll join us for all of them. People often ask, what does cancer have to do with the law? On your screen is a list of some cancer-related legal issues. Cancer affects the patient, survivor, families, healthcare professionals, and impacts many different areas of the law. If someone has a legal question and is affected by cancer, whether or not the topic is listed here, they can contact the CLRC for more information. The CLRC also has a professional panel, which includes attorneys from across the country who help those with cancer if a caller needs help with a matter in their state and practice area. You saw on the previous slide the practice areas that attorneys handle, but just to recap some of them: landlord-tenant, health insurance matters, medical malpractice, estate planning, employment law, and divorce law. It's a minimal commitment. All that the attorney agrees to do is a half-hour consultation. Anything beyond that is up to the person affected by cancer and that attorney. And it's very easy to apply. It's free to apply. So if you are a lawyer, we hope you will apply. And if you know a lawyer, we hope you will tell them about this opportunity. If you would like to view our resources on any number of topics related to cancer, please visit our website. Educational webinars like this one are recorded, so we can later put them on our YouTube channel for you to share with anyone who may want to learn about a variety of subjects. If you have questions about today's presentation, please type them in the chat box. I will be leaving time at the end to answer some questions. That part of the presentation will not be recorded. However, if you have questions about your specific situation or someone you know has a question you want to ask about, please fill out an online intake form at clrcintake.org, as you can see on your screen. After you do so, we can research laws and resources for you and provide you with free customized resources. Everything is confidential. Also, if you would prefer to do the intake over the phone, you can call the toll-free number on your screen. You don't have to fill out an online intake and do the call. It is just one or the other. With the generous support of the American Cancer Society and Breakaway from Cancer, the CLRC has a revised version of the Patient Legal Handbook. This handbook provides an introduction to the most common legal issues that a patient diagnosed with cancer is likely to face. It is available to download for free online in English or Spanish by going to our website, www.theclrc.org. Providers can request copies shipped to their offices for free. Both the handbooks themselves and the shipping is free. So today we're going to talk about the 5 legal tips, and actually, I'm not going to hide them from you. Here they are right on your screen. So I'm not going to wait till the end for you to find out all of them. I'm literally going to tell you them up front, and then we're going to take a look at them and do a deeper dive so you can make sure to really understand what they are. And just as the title of the series is, know your rights. So let's get started. So, legal tip number 1, it is the patient's responsibility to understand his or her insurance coverage. Tip number 2, don't take no for an answer. Tip number 3, request accommodations before your work performance is affected. Number 4, you may be able to take time off and keep your job. Number 5, document your end-of-life wishes before it is necessary. So there you go. There's the 5 legal tips. Let's take a look at tip number 1. So it is the patient's responsibility to understand their own insurance coverage. We recognize that this is an impossible task for some patients, but it is unfortunately how the law is set up. That means you have to read the fine print. People make the mistake in thinking doctors, surgeons, nurses, etc., treating us have to know what's covered by our insurance plans and what isn't, or to what extent. Even if they say they will call the insurance company to find out, it's always a good idea for patients to become familiar with their plans so that they understand their copays, deductibles, and networks. This helps to prevent unforeseen costs. You can find information online if your company offers an online portal, or ask your human resources for a copy of the policy if you get insurance through your work, or summary of coverage notice when you first buy your plan. Read the fine print. There are some laws that require insurance plans to cover certain services regardless of if it's spelled out in their policy. So I'll go over that information here shortly. Of course, having insurance in the first place is one huge step towards addressing practical financial concerns. One or more of the following options may be available to you. I won't go into a lot of detail about these different options, but suffice it to say that patients should be aware of their insurance options. We have additional resources available on the CLRC website. Employer-sponsored or COBRA may be a good option if you are leaving your job or have lost your job. It is expensive, but it can help maintain coverage after employment. An alternative and potentially less expensive option would be to purchase a new plan through the state marketplace. Some states have their own private marketplace, while others use healthcare.gov. It may be tempting to buy the cheapest plan, the one with the lowest monthly cost, but some of those plans with lower premiums may end up costing you more in the long run if they have higher deductibles or higher out-of-pocket costs. When you enter in your income on the website, you'll learn whether there are tax credits to help you lower the cost of your insurance premiums each month. The same is true for short-term health plans. They may be cheaper, but they likely don't provide the coverage that someone would need if they get diagnosed with cancer. Medicaid is a health coverage program run by the states. Eligibility is traditionally based on low income, low assets, disability. Some states have expanded eligibility to just income. Medicare is available to people who are turning 65 or those who have been eligible for SSDI, Social Security Disability Insurance, for 24 months. The most important thing I'll mention about Medicare is that we hear far too frequently from people who opt not to sign up for Medicare when they first become eligible due to already having other coverage or believing the card was sent to them in error. If you're nearing Medicare eligibility, either age or SSDI, please make sure you fully comprehend potential downfalls of not signing up during their initial enrollment period. It can lead to some severe penalties. However, these penalties don't apply if someone meets conditions that allow them to sign up during a special enrollment period. So we are the Cancer Legal Resource Center, so of course we're going to include some resources. Here are some resources. We highly recommend the Medicare Rights Center and your state health insurance assistance program. For additional Medicare resources, you can contact the CLRC through our online intake as well. Also, check the requirements and eligibility if your state has a health insurance premium payment program. I will not be discussing the specific prescription drug options available, but feel free to reach out to the HICAP office. If you're looking to purchase insurance through your state's marketplace or healthcare.gov, it is important to really look at the deadlines. It's important to also keep in mind that you can only purchase or change plans during an open enrollment or if you're eligible for a special enrollment period. For healthcare.gov, open enrollment is from November 1st to January 15th. And I want to mention that this is such an important topic and there's so much information about this specific area that the CLRC literally has another presentation as part of the Know Your Rights series about health insurance and open enrollment. And the timing of that presentation is actually leading up to the open enrollment period. So the goal really is for you to understand some basic deadlines and information from this presentation, but our health insurance and open enrollment is scheduled for October 12th, 2023. That presentation will be a great way for you to make sure that you're ready to make the most out of the open enrollment period, to understand what your rights are. So the goal of what we're talking about right now is for you to be ready and poised to learn a lot from that presentation, and also to have some takeaways now. But we will have a special presentation just about this topic. So if one enrolls from December 16th, 2023 to January 15th, 2024, coverage will begin February 1st, 2024. Some states have their own private online marketplace, while others use healthcare.gov. When you enter your information on healthcare.gov, if your state has its own marketplace, you'll be directed to the marketplace website. And I also want to mention that, as I had briefly discussed, this presentation is being recorded. The question and answer session at the end is not recorded. I stopped the recording then. But if you want to take notes, great. But also know that if there's a part of the presentation that you really want to focus on after this recording is finished, it will be available on our YouTube site. So you can literally go to the part in the presentation that you want to make sure to go over and write things down, and you'll be able to do so. Or, of course, you can watch the entire presentation again. So something that's important to highlight is that open enrollment time is limited to approximately 6 weeks. And another thing to keep in mind is, regardless of when your state's open enrollment period ends, if you want coverage for January 1st, you generally have to apply by December 15th. So it's a good idea to check with your state's marketplace as soon as possible to confirm your state's deadline for applying for coverage. If you can't get health insurance otherwise, here are some options. So first of all, private health insurance. Although this can be an expensive option, anyone can purchase private health insurance as long as they do so directly from an insurance company or through an insurance broker. Some people are not eligible to purchase through the marketplace due to immigration status or Medicare, Medicaid eligibility. Halliburton is a congressional law which gave hospitals and other healthcare facilities money for construction and modernization. In return, the facilities that received these funds agreed to provide a reasonable service to those unable to pay. The program stopped providing funds in 1997, but about 140 healthcare facilities nationwide are still obligated to provide free or reduced cost care. You can call the National Helpline to get a list of obligated facilities. Charity care. Many hospitals have free or low cost care available to low income patients. It's a good idea to speak with a social worker, financial navigator, or patient services at your local hospital department to determine what options may be available. You often have to provide information about your income and other assets. If someone is insured but is concerned about outstanding medical bills or the best ways to use their own insurance coverage, these tips can be helpful. Here are a couple of things to keep in mind to make sure you get the most out of your insurance policy. You can check with your insurance company to see if the insurance company has a case manager. If your plan or hospital does not offer case managers or patient navigators, ask to speak with the same person each time you call if possible. Positive rapport can go a long way, as insurance employees may be willing to spend time finding ways to reduce costs. It's the hospital's case manager that makes sure a patient's health insurance company understands what's happening during the patient's hospitalization. They make sure that the insurer has all the information it needs to approve payment for hospitalization and works to prevent insurance claim denials. The hospital case manager communicates with the health insurance case manager every day or every few days. Additionally, a hospital case manager might negotiate coverage benefits between a health insurance provider or insurer and the patient. The health insurance company's case manager receives information from hospital case managers, home health care companies, physicians' offices, social workers, and other healthcare providers. And I'd like to mention that if someone is helpful, I would definitely write down their name, try to find out their extension, what hours and days they work, because sometimes someone you're speaking to may be working in a different time zone. Of course, if someone is not helpful, you don't have to request to speak with them again. It's only really if you find somebody is doing a good job, and that might take time to find that person. But if that person is helpful, then it can save time that you may have a case number, or they may just also remember some of the details. So when you're speaking with them again, it might take less time to explain your specific situation. Now, when it comes to talking about conversations with providers, it can be awkward to have financial conversations with your providers. But at the end of the day, if you can't afford the treatments or prescriptions your provider is recommending, or you aren't adhering to the schedule or dosing because of cost, your provider needs to know. They can't help but recommend less expensive options if they don't know your situation. Keep dates and times and extension numbers in addition to writing down names. If you're required to get pre-authorization, request it sent by mail and keep it. If you fail to get prior authorization for a certain service, it can be difficult to get the service approved later. Open all mail, even if it seems daunting. Review all bills. Compare them with your explanation of benefits or EOB. Insurance EOBs explain what you owe the provider. Mistakes happen. I'll talk a little bit more about this later in the presentation. CLRC tip number 2. Don't take no for an answer. This is a life tip, but specifically a cancer legal tip in the area of health insurance denials and disability insurance denials. I'll talk about how this applies to health insurance denials and Social Security applications. If you are denied coverage of a health insurance benefit, you should not take no for an answer. Appeal. Private insurance companies have different procedures for appeals. I'll explain your rights here as it relates to private insurance. If you have Medicaid or Medicare, the procedures are different. For those with private insurance, the process for completing the appeal should be found in the denial letter sent by the insurance company and should also contain information about the strict timelines that must be followed for a successful appeal. Often, medical teams are unaware of insurance difficulties that patients face. Sometimes it is helpful to bring an insurance problem to the attention of your doctor's office and have them call your insurance to explain why a procedure is medically necessary. They can either help you appeal or help you go another route so you don't suffer with so much out-of-pocket expense. Many pharmacies partnered with oncologists are able to advocate for insurance coverage as well and have people on staff to facilitate getting coverage for patients. If you do appeal to your insurance company and they still deny you at the appeal stage, once you exhaust your options with the insurance company, you still have the right to an external appeal. An independent medical review or external appeal is an opportunity to have someone besides the health insurance company decide whether the company should pay for the service you're requesting. In California, for example, HMOs and blue PPOs go to the Department of Managed Healthcare. Other insurance goes to the Department of Insurance, unless it is self-funded, in which case the plan must contract with an independent third party. Usually, you have to exhaust the internal appeals process before you can move forward with an external appeal. This is not true if the situation is urgent. According to the Department of Managed Healthcare, in 68% of the cases, the health plan's denial of service was overturned and the enrollee got the requested medical treatment. Once the case has been decided, the health plan must authorize the services in 5 business days. The IMR is free, easy, and fast. In most cases, the IMR is decided within 30 days of receiving all required documentation. If you need more local one-on-one assistance in filling out the IMR form, please contact the DMHC or the DMHC's Consumer Assistance Program, Health Consumer Alliance at 1-888-804-3536. It's important to note that appeal rights might be available to those on Medicare managed care plans, but if you're on Medicare or fee-for-service Medi-Cal, appeal rights are different. Medications must first be approved by the Food and Drug Administration, or FDA. Until a drug is approved, it normally cannot legally be given to anyone except through an approved clinical trial or a manufacturer's compassionate use program approved by the FDA. Compassionate use programs allow a manufacturer to give certain individuals a medication that is being tested in clinical trials before the FDA has made a decision about approving or not approving the drug. When the FDA approves a drug, it is approved for certain conditions or indications on the label. Regardless of what the label says, a physician can legally prescribe an FDA-approved drug for any reason. This is called prescribing the drug off-label. Note that your insurance company still may not approve the coverage just because your doctor approves it for your use. Each plan has a formulary or list of approved medications. Formulary medications can usually be prescribed without pre-authorization. The insurance company, not your physician, decides what is on their formulary. Every drug company has patient assistance company you can contact to gain access to a medication. So, for example, patient assistance foundations are generally based around diagnosis and have some funding you can use to spend down throughout the year potentially. Another place you don't take no for an answer is with Social Security. Before I talk about denials, I'll just introduce the benefits really quickly. The Social Security Administration is in charge of 2 federal benefit programs, SSDI and SSI. They both have the same definition of disability. You must be unable to work due to a severe medical condition that is expected to last at least 1 year or to result in death. SSI, Supplemental Security Income, is based on assets and income, not your work history. SSDI, Social Security Disability Insurance, is based on work history. One must have earned 40 work credits, including at least 20, over the past 10 years. A work credit is currently defined as approximately $1,510 in wages or self-employment income. 4 work credits can be accrued per year. Younger patients have lower requirements. After 2 years of receiving SSDI, if you're under 65, you'd be eligible to receive Medicare. But you must show that the medical condition is keeping you from working or earning substantial gainful activity. It's a good idea to list multiple conditions. If a person has multiple things contributing to their inability to work beyond cancer, they should list them all. The Compassionate Allowances Program contains a list of medical conditions that allow for review in days as opposed to months. At the end of this presentation, there will be a link. If your condition falls on this list, you'd have to write in compassionate allowances somewhere on the application for benefits. The link that will show is, of course, to fill out an online intake. Unfortunately, there isn't a checkbox, and if you're applying for SSDI, there's still a 5-month waiting period. The application will be reviewed sooner, however, if you qualify for a compassionate allowances review. Many people apply for benefits through SSA, the Social Security Administration, and unfortunately, fewer than 50% of initial applications are approved. After appealing, the approval rate jumps to about 75%. The CLRC tip is to appeal rather than reapply. We say don't take no for an answer and appeal instead of reapply. And that's because you can be entitled to retroactive benefits. Payments may be retroactive back to the date your disability began, up to 12 months prior to your date of application. If an applicant reapplies, they will lose any retroactive payments. For those who weren't aware, SSDI benefits, if approved, are not payable for the first 5 months of disability. The Social Security appeals process has multiple levels, and there are very specific deadlines to appeal the SSA's decisions. Usually you have 60 days, but pay attention to any paperwork you received if you're applying for benefits. The steps in appealing are request for reconsideration, a hearing by an administrative law judge, the next step, review by the appeals council, and all the way up to finally federal court review. In some cases, hiring an attorney to assist you with your case may be the best course of actions, and then lawyers would take the fees out of back pay. The SSA has raised the statutory fee cap in free agreement cases to $7,200. Lawyers can't take more than that for helping someone with an appeal. Don't take no for an answer. If you want to have help filing an appeal, you can hire a private lawyer or legal aid. Contact the CLRC for legal resources. CLRC tip number 3. Wow, we're really making a lot of progress through these tips. We get a huge number of questions about employment issues, so I want to cover some employment laws here. It is your responsibility to let your employer know you need help doing your job if you aren't able to do so because of a disability, and notify your employer before your work performance suffers. The American with Disabilities Act and your state fair employment agency work together to prohibit discrimination against people with disabilities, which can include cancer, but it's not illegal to fire someone whose work performance is suffering. So that's why we added this tip in here. If an employee is not performing the essential functions of their job and their employer doesn't know about their need for accommodations, he or she can be terminated. Having cancer does not always prevent someone from being fired. I'll explain the ADA and what protections people with cancer do have in the workplace. The ADA, or the American with Disabilities Act, is the federal anti-discrimination law. It actually works to protect from discrimination in all phases of employment, and that even includes the application and interview stage. The ADA applies to state and local governments and applies to private employers with 15 or more employees. The ADA protects employees against discrimination if the employee qualifies for protection. There are 2 parts to this. Number 1, an employee must have a qualifying disability. The ADA defines it as a physical or mental impairment that substantially limits a major life activity. Every disability law has its own definition of disability, so note what qualifies someone for protections under the law. Under the ADA, cancer can be a disability based on this definition. The employee is only protected if the person is a qualified employee. Qualified means the person can perform the essential functions of their job with or without reasonable accommodations. The essential functions of a person's job vary depending on the nature of their work. As an example, an essential function of a delivery person, i.e. UPS, would be lifting, for example, over 10 pounds. An office worker might have to lift 10 pounds, but that probably isn't an essential function of the job. If there's no reasonable accommodation that would help someone do the essential functions of their job, then the employee isn't qualified for protection. If there's some accommodation the employer can give to the employee to help them do the essential functions of their job, then the employee is qualified. So if you are a qualified employee and your employer is required to abide by the ADA, that gives you certain protections. You then cannot be fired because of your disability, and you are entitled to reasonable accommodation, which I'll explain in a second. People with disabilities can still be fired, just not because of a disability. If someone's performance suffers at work, or they are late in sleeping at their desk, or if the company does budget cuts, employees can still be let go, even if they have cancer or another disability. This is a common misconception we hear about, but this is why we added the tip about requesting accommodations before your work is affected. Let me go on and I'll make this clear. As I mentioned, if you're entitled to, if you are a qualified employee with a disability defined under the ADA, you're entitled to reasonable accommodation, and that's any change or adjustment in the work environment that enables an individual to perform their job, a change in the physical environment, or a change in the policy. There is no one-size-fits-all accommodation. The accommodation must be reasonable, meeting the individual's needs without being an undue hardship for the employer. So, in other words, reasonable for both parties. For example, if an employee has a standing job like a cashier, but has a disability where they can't stand for long periods of time, it might be reasonable for the employee to ask for a chair where they can take sitting breaks. This isn't asking a lot of the employer and helps the employee. That is, it's reasonable. Or if it's reasonable, an employee can ask to work from home or modify their schedule based on circumstances of both the employee and the employer. The employee should notify the employer right away if they think there is a need for a reasonable accommodation. Let's say the employee has a condition that requires them to take more frequent bathroom breaks and just starts taking them. It might mean a little less work gets done, or they are less available. The employer could think the employee is slacking off. However, if an employee is asked for more frequent breaks to accommodate disability, then the employee is protected from negative action taken by the employer. That is why we suggest asking for accommodation before it affects work performance. This is a national webinar, so I'm discussing the law in California just by way of an example. We talk and focus in this presentation about laws that are federal law, so applying to all the states. Now, there are some specific state laws that can do the same as the federal law or give additional protection. So I'm just using California for an example. The Fair Employment and Housing Act is an example of California going beyond the federal law to protect its citizens. It prohibits discrimination in all employment practices against qualified individuals with disabilities who can perform the essential functions of the job, with or without reasonable accommodations. Basically, it provides the same protections that the ADA does, but is more inclusive. If a patient is not covered under the ADA because an employer has fewer than 15 employees, they are not out of luck. It applies to employers with 5 or more employees rather than 15 or more. The ADA says substantial limitation on a major life activity, while California's FEHA is broader and only says limitation on a major life activity. Under the ADA, cancer and the effects of treatment can be a disability, but under the FEHA, cancer is specifically listed as a disability. If you suspect discrimination in employment, it's a good idea to contact an employment law or labor law attorney right away to discuss options. Some people may be covered by both the ADA and state employment law, but before you file a complaint, check with an attorney. If you are a member of a union, contact a labor law attorney. We recommend speaking with an attorney because in some cases, a lawyer might think you have a good case for a lawsuit, or a lawyer can advise you which agency is the right agency to file with. It's a good idea to get some guidance before you make a decision on what action to take. CLRC tip number 4. You may be able to take time off and keep your job. So we get a huge number of questions about employment issues. Although laws like the American with Disabilities Act and the California Fair Employment and Housing Act prohibit discrimination against people with disabilities, which includes people with cancer, employers are not prohibited from taking negative employment actions against someone if their work performance is suffering, or they aren't performing the essential functions of their job and their employer doesn't know about their need for accommodations. It's generally the responsibility of the employee to ask for changes to the work environment or accommodations before the work suffers. So let's dive into the Family and Medical Leave Act, or FMLA. It is unpaid and it's 12 weeks, which the 12 weeks can be taken intermittently or out at once. And it can be 12 work weeks of unpaid leave during any 12-month period. So it's job and a health benefit protected leave per year to take care of oneself or a covered family member. The FMLA is a federal law that gives you the right to take off from work with continued health benefits, take care of yourself or a covered family member for up to 12 weeks. FMLA is not a form of income. You can take FMLA if you are the one who needs medical leave or to care for a child, spouse, or parent. Not all employers have to provide FMLA leave. Government, local, state, and federal employers do, as well as private employers. If there are 50 or more employees in a 75-mile radius. So this is where a lot of people run into issues, because unless you work for a large enough company or business, FMLA might not help you. But it's important to mention the 50 or more employees in a 75-mile radius, because if somebody works for a chain restaurant or chain coffee shop, they may not have 50 employees at their specific location, but within 75 miles, there may very well be another or multiple locations of the same business. So that amount of people could add up to 50 or more. So let's take a look at the actual words used and make sure we understand them and know our rights. So you can take advantage of FMLA if you've worked 12 months, doesn't need to have all been consecutive. If you worked 6 months 1 year and 6 months the next year, as long as it adds up to 12 months, that's fine. And you have worked 1250 hours in the last year, that averages about to 24 hours a week. So part-time employees may qualify. While on FMLA leave, you're on unpaid leave, but in some circumstances, an employer may require, and the employee has the right to choose, to use accrued vacation time or pay time off so that they get paid while on FMLA leave. Or an employer may require, and the employee has the right to choose, to use sick leave when the leave is for the employee's own serious health condition. So if you take 3 weeks of vacation, if you have 3 weeks of vacation accrued and 1 week of sick time, and you're eligible for FMLA, you most likely will not get 16 weeks off from work. Most employers would require use of sick and vacation time concurrently with FMLA, which means that the 12 weeks of unpaid leave would turn into 4 weeks of paid leave due to use of sick and vacation time, and then the rest of the time off would be unpaid. It is possible to take time off from work even if you don't qualify for FMLA or if you have exhausted your time off. It's important to note that the FMLA can work alongside the ADA. For example, if you took 12 weeks of FMLA leave but were not ready to return to work, additional leave may be granted as a reasonable accommodation under the ADA. However, courts have held that the ADA generally does not protect workers who have erratic, unplanned absences and whose accommodation involves being absent from work. To be protected under the ADA, you must be able to perform the essential functions of the job. If attendance is an essential function of the job, then one cannot be protected under the ADA. In other words, courts have ruled that attendance is a basic job requirement. For example, if you're a surgeon, then attendance may be an essential function of the job. It's hard to telecommute in for a surgery. So if you're asking for additional leave beyond the FMLA, It can only be a reasonable accommodation when there's a definite end to the leave and when the employee's absence does not pose undue hardship on the employer. So you might be eligible for the 12 weeks and then have a doctor's note that says you need to take additional 5 days off for recovery. That extension may be treated as a reasonable accommodation. But if you tell your employer that you need more time off, but you aren't sure when you'll be able to come back in, they'll probably say that's an undue hardship to keep your position open indefinitely, and then they'll deny the accommodation. So, for example, one of our callers worked for a large company with a very generous leave policy. After 2 years, she was finally going to be terminated and inquired whether her employer could actually do this. Unfortunately, no employer is required to hold someone's job open indefinitely. And after 2 years on medical leave, it likely wouldn't have been reasonable to ask for another extension of medical leave. Wow, we have already reached our final tip, CLRC tip number 5. No matter a person's health, it is important to make future plans for your health and property and do so before it's necessary. People should not wait until they are sick or at the end of their life to do advanced planning. Having said that, there's never a bad time to do advanced planning. If someone hasn't done it yet, they should consider doing it if they want to, and not just because they waited a long time so they don't want to do it. At least if it's something that you don't want to do, I can understand, but it's a good idea to know your rights and what the various options are. And the way to think about this is that no one lives forever, even Betty White. So it's a good idea and actually it is empowering to express your wishes so that your wishes can live beyond your life. So even if you think that everyone, friends, family, knows what you want, if it is not in writing, then it may not be sufficient and could leave your friends and family in a difficult situation of trying to figure out what to do. And also, when you leave clear instructions, it could actually help those that care about you have the clarity and would actually potentially reduce disagreements between those who care about you as to what you might have wanted. Because after all, it is spelled out for those who will see it to understand what your wishes are. You are the only one who knows your true beliefs and desires down to what you want to happen if you cannot care for yourself. This is true when it comes to decisions about healthcare, as well as decisions about dividing our property. I'll discuss some common advanced planning tools here in the next few slides. I also want to say that if you don't create a will, then each state has what is essentially a template for a will. So if you don't make one, the state's going to give you one. So who better to know what your wishes are, the state or you? So that's just something to consider as you're learning about what advanced planning options are and what might be right for you. The key to advanced planning is to do it in advance because before someone becomes incapacitated or their judgment may be called into question by medications or illness. Advanced planning can be broken up into parts, one that focuses on property and the other that focuses on healthcare. We're all somewhat familiar with wills, but there are formalities that need to be followed to ensure a will is valid. So a lot of the information as to this topic is based on the state. So I'll just, again, use California again, just as an example, but certainly you should be checking what your state's requirements are, or you can contact the CLRC and we'll do research for you as to what your state's requirements are. Wills can be constructed in 3 different ways in California. They can be prepared by an attorney and signed by witnesses. This is usually the preferred format to ensure that the will meets all requirements. A person can fill out a statutory form from the California Bar website if they do not have complex assets. Additionally, a caller can handwrite, sign, and date a will. If the will is not created with the assistance of an attorney, it is best to have it reviewed by an attorney to ensure it is valid. A trust is an arrangement whereby one person, called a trustee, holds legal title to property for another person, called a beneficiary. There are many types of trusts. You can create them separately while you are alive, a living trust, or through your will, a testamentary trust. The main advantage of a living trust is that it avoids having a family having to go through probate court after a death, which can be expensive. So one basic tool for advanced planning is a will. A will is a document where you can basically lay out who you want your property to go to, but there are formalities to create a valid will. The rules about what constitutes a valid will are determined according to state law. So it is important to consult local resources or call us at the CLRC to find out how to create a valid will in your state. There are generally 3 ways to create a will. Number 1, a holographic will. Number 2, your state's statutory will. Or number 3, to have your will prepared by a lawyer. Number 1, in California, a person can write a will purely in their own handwriting. As long as it's all handwritten and signed and dated, it can be recognized as a valid will, even without witnesses. This is called a holographic will. Some states recognize holographic wills. California is one of them. I would definitely check with your state before deciding that as an option for you. Number 2, a statutory will is one where you fill out your state's statutory form, have it signed by 2 witnesses and notarized. And number 3, another way is to create your will is to hire an attorney. A qualified estate planning attorney can make sure that your will conforms with state law, whether you want the attorney to draft a will for you or just review one you've prepared by another method. The attorney can also offer suggestions and help you understand the many ways property can be transferred, which can be economical in the long run for you and your beneficiaries. The CLRC has referrals to some attorneys who might be able to help, including legal aid organizations in certain locations. I also want to point out that some people don't always think about the fact that if they have pets, they may want to account for who will care for their pets. And sometimes creating a will enable someone to start to think about these issues. And also, one misconception that people have is that maybe they don't have that much money, so why create a will? But it is really important with whatever you have that it goes to who or is handled however you wish it to be handled. And in fact, for example, with the example of a pet, it may actually cause you to ask someone, about if they'd be willing to care for the pet. You may not even know, but they may be unable to, or they may have an allergy, or there could be other considerations. So it definitely can prompt someone to ask important questions and find the best care, for example, in their situation of having a pet. A trust is an arrangement where someone, you, the grantor, settler, trustor, transfers legal title to property into a trust for the benefit of another person, a beneficiary. The creator of the trust names a trustee who will manage the property and distribute it for the benefit of another person, the beneficiary. There are different types of trust. The most common is a living trust. This is created to go into effect during the grantor's lifetime. The grantor can name themselves the trustee and retain ownership and control of their assets during his or her lifetime, and name someone the successor trustee to manage assets upon the person's death. It can be more expensive to set up initially, but it makes the property easy to distribute after death. Another type of trust is a testamentary trust, which is effective only upon one's death through their will. It's always best to consult with an attorney about which estate planning tools make the most sense for your situation. Transferring asset titles to trust is the part that can be really tricky and therefore expensive, but it makes it easy on beneficiaries at death, oftentimes avoiding complicated probate. An attorney may charge by the hour or a flat fee to create a trust. If you have a living trust, you may still want a pour over will. This directs that any property that is not already in your trust be put in the trust at your death. So if you buy a car or anything before your death, the haven't specifically included in the trust you created, this catch-all directs whatever unnamed property to go into your trust. So I mentioned this briefly earlier, but just wanted to discuss this a little more. If someone dies without a will or a trust, this is referred to as dying intestate. State law will determine where your property goes if you have not provided for it in a will or other estate planning document. If you have not created a will, typically the property will go to your spouse and children. If you have neither, it goes to other relatives like parents, siblings, nieces, nephews, and cousins. If someone has no surviving relatives, then your property goes to the state. If you don't own much by way of property, maybe you don't really care about having a will in place. However, remember that pets do count as property, and often people forget to make plans for them. Some property already has a designated beneficiary, like life insurance policies or bank accounts. These must be changed through the company rather than through a will or other document. People at the end of their lives or people who are going through intense treatment often need assistance in managing their financial affairs. A power of attorney for financial affairs is a legally binding document that you prepare or have prepared for you, where you choose a trusted person known as your agent to make financial decisions for you. This means they can manage your finances and they can dispose of your property or sell your property during your lifetime. You don't lose authority to manage your finances unless you become incapacitated or unable to make decisions for yourself. This is not the same as a power of attorney for healthcare or healthcare proxy. I'll discuss that shortly. But it's a good idea to talk to an estate planning attorney to name someone to make decisions for you should you need an extra hand managing your finances or you should become incapacitated. Then you have someone named who will get to make financial decisions for you. It must be notarized or signed by 2 witnesses. I just want to make the point that the issue of incapacitation is not something that the person that you would name as a trustee would get to decide or you get to decide. That is a decision that would be for the physician who's treating the patient and or the judge to decide. So it is not, you don't have to worry just because you name someone that they're going to claim that you're incapacitated. That's not how it works. It actually is a medical decision reached by the doctor, again, the judge as well, that would decide on that information. Advanced healthcare directives are written instructions that state a person's wishes about the medical care and treatment they want to receive if they aren't able to make medical decisions for themselves. Advanced healthcare directives are intended to avoid unwanted care, reduce suffering, and ensure that a person's wishes are honored at the end of their life. For example, one can state their desires regarding life-sustaining or life-prolonging medical treatment or pain relief. In California, again, I'm just using California as an example of how one state might approach this, but different states may have different policies. In California, there are 4 parts in Advanced Healthcare Directive. You can find them online at caringinfo.org. Number 1, power of attorney for healthcare, otherwise known as a patient or rather an agent or a patient advocate. Number 2, instructions for your healthcare. Number 3, organ donation. And number 4, primary physical identification. A living will, also called a directive to physicians or advance directive, is a document that lets people state their wishes for end-of-life medical care in case they become unable to communicate their decisions. It has no power after death. Wow, so we have now reached the end of our presentation. Here are the CLRC's 5 legal tips and the topics we covered today. I'm going to go over them before we completely wrap up, and then I'll stop the recording and we'll leave time for questions. So here is the 5 legal tips we discussed today. You could be so proud of yourself of how much you learned. And here we go. It is the patient's responsibility to understand their insurance coverage. Number 2, don't take no for an answer. Number 3, request accommodations before your work performance is affected. Number 4, you may be able to take time off from work and keep your job. Number 5, document your end-of-life wishes before it is necessary. Thank you for participating in this presentation. Please remember that if you have any questions that are specific to your situation, you can either call the CLRC or fill out an online intake, and we will get back to you.